Hi everyone, this is BritSimon. So tomorrow, July the 19th, Monday, there is a very significant, very important hearing for DV Lottery. And I thought I would record a video as a preview to that to explain the sort of things that will be discussed tomorrow, and try and sort of make the process a little bit more understandable for those of you that want to listen in. It's not necessary for you to listen in. You don't have to, but no doubt many of you have got questions, and some of you will want to understand the process and understand the transparency, using the transparency, how the process is being worked. I think it's important for some of you to understand that there is law being applied here. The USA is a country of laws. It's a country of justice, and there is a process. That process isn't always fast. It doesn't always get us the results we want, but there is a process. And so it's interesting, it's informative, but it's, for many of you, it's going to be very important to understand what happens tomorrow. So let me firstly say, I'm not a lawyer. I'm going to speak about some of the terms here, and I'm going to try and put things into layman's language where I can, but I also may make some mistakes in doing that aspect, in translating the law into layman's language, or I may even have some fundamental misunderstandings of the process myself. So if I do that, I apologize. That's not my intention to make it more complicated or worse for any of you, but hopefully people will find this interesting and helpful. So let's just talk about what's going to happen tomorrow. Firstly, the lawsuit is on a number of different cases. My dogs are going to go nuts. Sorry about this. So it's on a number of different cases, right? So recently, the Gomez case was included in a hearing that was already scheduled. So July 19th has been a scheduled date for a hearing in some of the 2021 cases for some time. And then in the last couple of weeks, not surprisingly, frankly, to me, apparently it was a surprise to some, DV 2020 case, the Gomez case, was included in the hearing. So the cases included in the hearing is the Gomez case, which includes the Aker, Fongjon, Mohammed, Kennedy lawsuits. All of those lawsuits are combined into one bucket, as it were. That means representation from the AILA team will be there, Jesse Bless and so on, the Justice Action Law Center, Charles Kuck and co, all of those lawyers, Curtis Morrison and co, all of that team. And so all of them will be there to consider the aspects for the DV 2020 case. That's one case. Then there's the GO case. The GO case, G-O-H, GO, is the case that represents about 1,000 cases through the Kuck, Siskind, Joseph and Hall sort of group, which they call themselves the Impact Litigation Team. Then we have the Goodluck case. Goodluck case is Curtis Morrison, Raphael Urena, and others who are working on that case. That's a huge case with about 24,000 selectees. It's about 11,600 cases, but representing about 24,000 people. And then Filazopovich, which is the Glazer and Glazer case. I don't know much about that one, I have to say. Nicolette Glazer, comments on Twitter, but she and I have had very little interaction. I don't know quite what her strategy will be, but nevertheless, she's included as one of the cases, or her case is included as one of the cases tomorrow. The hearing is at 1 o'clock in the afternoon on the Eastern time zone. I'm going to put a link below to how you can find out what time that is in your country. it's different time zone to where I'm in. It'll be 10 a.m. my time. I'm in California on the Pacific time zone. So have a look and see what time that will be for you in your part of the world. There's a public access line to be able to listen in. I'll publish the phone numbers both in a USA number format and also a landline number format, which might be more useful if you're using something like Skype or something like that to listen in. However, probably an easier way to listen in is the court have said that they'll publish the feed, the hearing feed, just audio, on the YouTube channel, and I'm putting that in the description below this video on YouTube and also on my blog. And that will probably be quite a useful way to listen in. I expect the hearing to last about 3 to 3.5 hours, right? So it's going to be a long hearing. It'll be the whole afternoon. And because there are so many cases involved and so many lawyers, etc., it's going to take all of that time, I'm sure. There is some. Charles Kuck had published a sort of an order, and I wanted to explain what that order really means. There is a sort of an ordering of how they're going to approach the thing. But let me just frame that by saying that Judge Mehta he's aware at this point of the DV lottery process. He's aware of the issues that came up in DV 2020. That, frankly, is why even before DV 2020 case was included, to me, it was obvious that the DV 2020 case would be included in this hearing in some way, at least in the mind of Judge Mehta, at least in the mind of the lawyers, and for some very specific pieces of decisions that were made in DV 2020, right? It's impossible, frankly, to separate those cases out. The issues that have already, some of the issues being argued in DV 2021 by some of the lawsuits have already been argued and won already in DV 2020. Okay, so there is an obvious connection between the two years, and frankly, this might also become important for DV 2022 as well, because the behavior is continuing. The government's behavior on how they operate is continuing. And it's a problem. So let's just sort of talk about the order of processing as far as the plan goes. I mean, obviously, this is like anything. You make a plan and then you throw the plan away and you get on with just the conversation. But I think that Judge Mehta is going to try and stick somewhat to this order. So the first topic will be justiciability or justiciability, I think is probably the way it's pronounced. So this relates to standing and whether the people suing have the right to sue, and whether the court hearing the case have the right to make decisions, etc. Whether there is jurisdiction in the case, whether any aspects of the case are already moot, for example, or whether the people who are suing have the right to sue because they've been affected by some action, right? That whole topic is sort of a technical formality. Some cases are won and lost at that point. But in this particular case, it's very obvious that we have standing. We've already had that argument in previous lawsuits, etc. In front of Judge Mehta. He's already taken action. It's obvious that he believes he's got jurisdiction over some of it, at least. So to some extent, I believe that's a bit of a technical formality. There shouldn't be too much interesting in that early part of the hearing. There shouldn't be too much argument about that. I think the government lawyers probably will argue even that. Frankly, they will try and make arguments because they're lawyers. They're paid to argue. That's their job. I mean, people that are surprised that the government lawyers are still arguing when Biden is in office just confounds me. Of course they're going to argue. They're lawyers, just like a soccer player keeps on playing soccer. That's their job. That's what they play. That's what they're paid to do, and that's what they do. And they use any techniques they can to win their case, even if sometimes they believe they're in the wrong. they're going to do that anyway. They're going to try and win the case. So the government may introduce some topics around standing and around jurisdiction, etc. But I don't expect those to be very compelling. I don't expect those to be a real issue. The next section will be the INA 212F interpretation and delay. 212F is the part of the Immigration and Nationality Act, that's what INA is, that refers to the president's ability to stop immigration into the country if he feels that's necessary. Now, this is more or less a done deal in terms of the president having that ability. We know that President Trump basically tried to close the borders to immigrants, etc. He did it in some pretty horrible and questionable ways, shall we say. I won't get into the politics of it too much, or I'll try and avoid it. But nevertheless, the courts found that the president does have the right to make certain rules about how immigration is controlled and what people are allowed to enter the country. But the case, in a sense, hinges on the next step of that. What the government did was they relied on the fact that the president can stop people entering the country, and they used that to justify not processing visas. That was turned into what the court has dubbed, and the lawyers have called, the no visa policy. So when I talk about the no visa policy, it's about this difference where the president of the United States has the right to say, no, we're not letting in immigrants of this type or from this country or whatever else. He has that right, and he exercised that right. But that is not the same right as saying you can't process the visas. You can't adjudicate visas, you can't process them. There is no part of that law that allows him to sort of stop the processing. Now, that central point was heard and was decided in the DV 2020 case last year. Judge Mehta decided that the government did not have the right to not process cases, and that they should issue visas even if those visas couldn't immediately be used. And of course, as we know, in September of 2020, that meant a lot of people were issued visas that were then put into a sort of a limbo because they had been issued visas, but certainly while Trump was around, those people were not allowed to enter the country. And eventually, through another court decision, we got to the point where those people were given the right to enter the country. Again, Judge Mehta stepped in and said, okay, the government's not playing fair here. So I'm going to make it fair. I'm going to say that if you were issued a visa in DV 2020 in September, then you will have the right to enter the country, even if that visa has expired. And so he did that just before some visas expired. But he basically set up a situation where lots of people were able to enter with the visas that they had been awarded in September of 2020. So Judge Mehta took very strong action on this no visa policy in September by forcing the government to process and adjudicate these cases. And we got 7,000 visas issued in the last 3 weeks or so of 2020. And then when it became clear that the government, even under Biden, were not going to do the right thing and allow those people to enter, he then stepped in and put that right as well. So he's taken already some very strong action on the no visa policy, and he's been very clear about that aspect. So the section about INI 212F about the president's ability to stop immigration, is going to be an interesting topic because we know how Judge Mehta believes that should be operated. He respects the decision or the position of the president to not allow entry, but when it came down to it, he said, actually, you've issued these visas. It was right to issue the visas. Now we're going to play fair. You're going to do it. You're going to let them in. And so, so that'll be interesting. But the way that that's set up is it's a discussion about the interpretation of that policy and the delay caused by that policy. So this is an important point, because what we know is that KCC basically stopped working because of the no visa policy, right? They stopped processing DV 2021 cases, and we're now massively behind in terms of processing. All the regions went current because of the lack of processing and the lack of work by KCC. I mean, a lot of the mess we're sitting in now can be focused back to the no visa policy, which Judge Mehta believes, he's trying to respect the position of the government and the president, but at the same time believes that there is a different way to look at things in some respects, right? So that whole section is going to be interesting. The next section is going to be case-specific claims. This will be an opportunity for some of the lawyers to address individual issues that are specific to their cases. So we've got all those different cases in play. This will be individual points, and I'm going to raise a couple of those points in a few moments as to what I think they should be arguing and what they are going to be arguing. And then finally, how relief would work. So that was an interesting one to list on the this is an agenda for the meeting, for the hearing. And when you list on there how relief will work, it's pretty sure that you're going to give relief, right? I don't think Judge Mehta has set up a 3.5 hour hearing with the last bulleted agenda item about how relief will work if he doesn't plan to give some sort of relief. That's not to say that we're going to get everything we want. Please don't misunderstand me when I'm making this point about how relief will work. We may not win in every case. It's very unusual, frankly, to win all of your arguments in a hearing, in a lawsuit. I don't think we will, and I'm not suggesting we will. But the ones that we win will be important. The points that we win will be important. So we'll have to see how that goes. But anyway, how relief will work. Relief meaning, what remedies can he do? What sort of order can he craft? What can he force the government to do? What he can't force the government to do? And there's going to be lots of discussion about that. Things like, can you force an embassy to open its doors to people that may come in and infect your staff with COVID? No, you can't do that. But you can say to the government or to this embassy, we don't care how you do it, but find a way of interviewing those people. Put them behind a glass screen if you like. Do it by by remote interview if you like. Do whatever you have to do, but do something for those people. So he can say something like that, but he can't force an embassy to open. Where the embassy is necessarily closed. And we've had a couple of the embassies where actually staff have died through contracting COVID. And so, there's a justifiable reason why some of the embassies may choose to stay closed. So the other thing that he can order is that the government are more cooperative in moving cases from one embassy to another. For example, if you're going to say that Embassy A is in the middle of a crisis with regard to COVID in the area, and that one is closed, but there's a relatively near country which is relatively easy for people to travel to, and that embassy is operating, then okay, then tell them to accept those other cases, or explain to us why that's not possible. Okay, so that's what I mean. There will be some level of detail paid about how the relief will work. I hope they get into that level of detail. If not, if they don't get into that level of detail, then we may find ourselves coming back in a few weeks' time to actually sort of adjust whatever decisions come out of this hearing. And actually, just before I go into the next topic I wanted to talk about was, I just want to make that point. We may not have an answer tomorrow. We may not have an order tomorrow, okay? In fact, I think it's most likely we won't have a decision or an order tomorrow. It's likely to come several days later, and certain of the cases could require another hearing. it's not, it's not necessarily going to be an instant relief thing. It's not going to be like that. Okay, so please don't think that, by tomorrow evening, all of our problems will be solved and we'll have an order from Judge Mehta and everything will be, super duper. We still face some challenges. Okay. Okay, there's some specifics that I wanted to get into about individual cases. So in the Goodluck case, Curtis has actually put on Twitter the four things that they're arguing for. And I wanted to list those and use those to talk about the case. So number one is reserve the visas, right? Now, bear in mind that the Goodluck case is 24,000 people. So when he says reserve the visas, he probably means for his selectees, for his cases, but frankly, that's a large chunk of people. So at that point, it could be reserve all the visas. Who knows? That's a pretty ambiguous statement, but that's his first statement. Declare no visa policy and prioritization scheme unlawful. The first part of that, the no visa policy, we already know the answer to that one. We know that from the point of view of saying that you can't process visas, etc., we already know that's going to be one. The prioritization scheme, I'll come back to in a minute. Number three, enjoin Biden administration from using these unlawful policies to cause plaintiffs delays, right? So it's because of the policies, the two policies that Curtis is talking about in point two. Enjoin means stop the Biden administration, stop the government, stop KCC and the embassies from using those policies to delay the plaintiffs, right? So that's what that means. And then number four is mandate process applications. Mandate, that's what I've copied exactly what he wrote, but it's kind of, I think he was talking in Twitter terms. Mandate process applications, so mandate or tell the government to process applications, schedule interviews, and issue visas to eligible plaintiffs. In other words, do your job, right? This is more or less like a mandamus sort of instruction, but mandate is a strong word in law, and it's an order. It's an order that you do this. Now, there's some problems with that, but I'll come back to that. But I did say I'll come back to the prioritization scheme. So in point two again is declare the no visa policy and the prioritization scheme unlawful. No visa policy, as I say, not a problem at all. We've got that one in the bag. We know that that's going to be Judge Mehta's position. He's already decided DV 2020 case based on that no visa policy as being unlawful. And he took action against it, and later on he took even stronger action against it. But the prioritization scheme is an important point. So the government, for whatever reason, and they've justified what their reasons are, has set out a priority which puts family-based reunification visas at a high level in a priority list. And it puts, amongst others, DV cases at the bottom of the list of priorities for immigrant visa processing. So it's not quite like that. There's actually four levels, four tiers, and DV is in tier 4, along with some other visa types as well, some other immigrant visa types, but tier 4. And basically, the prioritization says you're going to focus on levels 1, 2, and 3, and if there's any time left over for an embassy, then you can do some of the visas from tier 4, right? And that is why we're seeing embassies who would normally be able to handle 300 or 400 visa interviews in a month, doing maybe 20, 30, 40 visa interviews in a month if we're lucky. That's why we've got embassies like Stockholm, for example, saying that they are only doing the family reunification interviews, and they're not doing any DV interviews. It's quite brazen, frankly. It's a brazen disregard of even their tier system that they would say such a bold statement, but they absolutely have. And Stockholm Embassy have been helpful to DV cases in DV 2020, for example. They took a much more proactive, helpful view. So so this is, we've got a varying sort of landscape of behaviors from all around the world in all of the embassies, as well as KCC themselves. And it's sort of underlined and justified by this prioritization scheme. And the prioritization scheme itself is based on this sort of, frankly, pretty shaky argument that the government have made, that they say, well, look, this is the way that the Congress have actually laid out the laws. They've said that there is an ordering, and they point out to the order of the immigration rules, right? Where there is, for example, there is some prioritization in some of the areas that says family preference number 1 is going to be more, is going to have more visas than family preference number 2 and more than number 3, and so on. Right? There is a sort of a prioritization scheme within the visa classes, but there is not a prioritization scheme, as far as I can find, and as far as any of the lawyers have found, that says DV lottery is lowest of the bunch. It is less important than family reunification. There isn't such law. And so that's what Curtis is saying when he says it's unlawful. The government can't just arbitrarily decide for themselves, what they think is the appropriate sort of ordering. They have to have some sort of justification in law. And if they haven't got that justification in law and they've behaved that way, then their behavior can be challenged, right? And so that's exactly what we're doing. And that's very important, because if in February, for example, I believe it was February, if in February, when I cheered everyone and said, hey, the PP 10014 is gone and, we can move on, if at that point they had taken immediate action and suddenly started processing, 3,000-4,000 cases per month for interviews, then we would have, frankly, we would have nothing to argue about, or very little to argue about at this moment, because we would have got most of the visa cases through, maybe 35 to 45,000, something in that range. Perhaps not all 55,000, but we'd have quite easily got to 35 or 40,000 visas being processed, and they've wasted all of that time. And in fact, we now realize that they had wasted the time before as well, because they hadn't been processing cases. So they, through their behavior, they have caused the delays. So those are going to be the important topics for argument tomorrow. I think that probably sort of covers most of what we will hear. Charles Kuck and Cook, Siskind, Joseph and Hall will have a slightly different strategy from their point of view. Their point of view is going to be mainly about the Go case, is going to be, here's our 1,000 selectees, go process them, take care of these. So there will be an interesting sort of difference in the way that that team of lawyers argue, as opposed to Curtis Morrison. Okay, so that probably covers how we'll be expecting tomorrow to go. I hope many of you will listen in. I think it'll be useful. For myself, I can't take the whole 3 hours and listen into all of it, and so I probably won't be live tweeting or doing anything like that tomorrow, because I've got a hectic day of work tomorrow. But I'm going to find a way of catching up with all of it, as quick as I can, and I'll do a video tomorrow night explaining what I think I've understood to be the situation. And I think actually there should be a sort of a recap of that from the various lawyers as well. There may even be a video session from the Impact team tomorrow night, and I'm quite sure that somebody, one of the lawyers is going to be live tweeting or talking about the whole case and how things went tomorrow. So we'll see how that goes. All right, everybody. I hope this has been useful for you. Hope it's illuminated some of the points here. And, fingers crossed for tomorrow. It's a very important day. It's a very important hearing. As I say, we may not get everything we want, and we may not have an answer tomorrow, but it's really important that this goes well. So good luck to all the lawyers. And let's hope that they're on their best form and they have the best information available to them to make the best arguments they possibly can. And let's hope that Judge Mehta, will see a way to protect all of the DV 2020 and DV 2021 people that he can. Okay. All right, everybody. Thank you. Bye bye now. Keep well.